Good afternoon to all my dear student friends. Today we are going to discuss about the Companies Act 2013. So in this deliberation of 1 hour, we shall discuss about the introduction of the Companies Act 2013 and how the company is formed, what are the principal documents of a company like your memorandum of association, articles of association, prospectus, the share and loan capital, and the how the company is being managed. That is your company management, the meetings, and if it is decided to close down the show, so that is your winding of companies. So after hearing this deliberation, the students will be able to understand the meaning of the company as one form of business organizations and how company is defined and what are the characteristics of the company, how many types of companies are there, and students will be able to explain what are the different stages that one has to go through in the formation of the company and what is the necessity of your memorandum of association, articles of association, apart from the meaning and the importance it carries and the contents it must have, including the prospectus as one of the principal document which is required for the formation of the company. The students will be able to explain the meaning of the shares capital, your debentures, your deposits, everything. And if we decide to close down the company, then what should be the mode of winding of company? So let us start from the introduction of the Companies Act 2013. You see, we are doing business and the business is being expanded. So the expansion in business, sometimes they require an unlimited extent of capital. But in that case, the unlimited liability of the partners of the traditional partnership, which we discussed in the last session under Partnership Act 1930, that became a hurdle to meet the capital requirement. So, corporate form of business, when we look for help, in fact, to solve the problem, and the problem could be solved through introduction of the concept of limited liability. So if you start from the formation to its winding of company, these are all being governed by your Companies Act. So apart from the Companies Act that we are more concerned about, the Parliament of India has enacted several other acts like Company Secretaries Act, your Competition Act, your MRTP, which has been replaced by Competition Act 2002, your Partnership Act, everything, because all these acts to address the different issues of doing a business and how the business is being protected. So initially, even though we talk about Companies Act 2013, but the Companies Act started way back in 1956. So we always call Companies Act 1956, which in fact preceded the Companies Act 2013 because all over we have numerous, I would say, we have got numerous amendments, making it a complicated legislation, I would say, with some kind of overlapping of provisions. As it was becoming increasingly difficult to implement the Companies Act 1956, the need, necessity, urgency to streamline the legislation and how best we can reduce the regulations was reorganized. So as a result, if you look at the Companies Act 2013 was enacted and it was also consolidated all the amendment made over these years. So Company Act 2013 is divided into 29 chapters containing into 470 sections and 7 schedules. So if we look at the applicability of the Companies Act 2013, the provision of the Act applied to the companies so incorporated under this Act, under any previous company law. It will cover your insurance companies, your banking companies, your companies which have been engaged, in fact, in the generation of electricity, companies which have been engaged in the supply of electricity, and any other company you may talk of governed by some kind of special act from the time being in force. So in each of these, we have to see that how the company is formed. So we need to talk about the formation of a company. When we look at the company means what? Company means a company which has been incorporated under this act or which has been incorporated under any previous company law, that is your section 220 of the Companies Act 213. So when we define company like this, the definition doesn't clearly bring out the meaning of the company. So to define the nature of the company, to understand the nature of the company, the outside attempts or any kind of judicial decisions may be explored. So accordingly, we say that the corporation is an artificial being and invisible. The corporation intangible but existing only in contemplation of law. So when I say it exists in contemplation of law, being a mere creation of law, what does it possess? It in fact possesses only those properties which are the charter of its creation and confers upon it either you can say expressly or accidentally to its very existence. So that is why a company is an incorporated association, we used to say, which is an artificial person, and the artificial person created by law, having a special entity with perpetual succession. It will last for an indefinite period of time with a common seal. So the definition, if we look at minutely, sums of the meaning as well as the features of a company very succinctly. So if you look at the features, the distinctive features of the company, which is going to help to understand the realms of a company. The first feature would be your incorporated association. So registration of a company is mandatory. And when we say that registration of company is mandatory, obviously in case of public company, and two in case of private company, and 7 in case of public company minimum, 2 in case of private company minimum, and you have to see. So these are very much required as per the provision, because registration of a company is mandatory under the case of public, and 2 in case of a private company, and 1 for one person company. So another feature is your separate legal entity. On, I would say, incorporation, a company acquires a unique character. What is that unique character? Unique character of being a separate legal entity, and it bears its own name and acts under the same assets and owns the assets in its name. So it has a separate, I would say, existence from that of the subscriber, those who have subscribed their names to the memorandum association, and also from the personality of those who compose it. So the members, they can enter into contract with the company. They can acquire right against it. The members can incur liability to it. So for the debts of the company, only its creditors can sue it and not its member. So a company can own property just like you have bank account, company can have a bank account, company can raise loans, companies can incur your liabilities, enter into contracts. A company is capable of owning property, capable of enjoying property, capable of, in fact, disposing property in its own name. Although the capital which we are more concerned about and the assets which are contributed by the shareholders, the company becomes the owner of its capital. The company becomes the owner of its assets so created. So the shareholders are not the private owners, or the shareholders are not the joint owners of the company's property. So as a member doesn't even have an insurable interest in the property of the company. And another feature is your perpetual succession. A company, when we are talking of once incorporated, can never be incapacitated. So I repeat once again, whenever we are talking of a company once incorporated can never be incapacitated till it is wound up, maybe on the ground of specified reasons by the Act. So its members may come and go, but the company goes goes on forever. Even the death, the money is not there, but company is going. There may be insolvency of its members. There may be retirement of its members. Leaves the company, but company is very much unaffected. Another feature is your limited liability. That is, limited liability means that the members of the company, in case of liquidation or in case of winding off of the company, cannot be called upon to contribute more than what has been agreed. So obviously, if you look at the liability of the members, they all depend upon the kind of company of which he is a member. So in case of limited liability company, if we look at the liability part of the members, it is all limited to the extent the nominal value of the shares held by them. So in the case of a company limited by guarantee, the members are very much liable only to the extent the amount guaranteed by them. And that too, only when the company goes into liquidation. But however, if it is an unlimited company, obviously the liability of the company is unlimited as well. Another feature of the company is your artificial person. A company, National Aluminium Company Limited, company is an artificial person created by law. And this is clothed with all the rights of an individual and being subject to duties. So it is called an artificial person since it is invisible, since it is, I would say, intangible, but existing only in the contemplation of law. So as a legal person, what it will happen that it can enter into contracts, it can possess properties in its own name, it can sue, at the same time it can be sued by others. So obviously in that connection, it would be appropriate to mention that the company operates as an artificial person, not a natural person like all of us. And you have right to equality, which is available to the company, and it has nationality, it has domicile, it has residence. Another feature is your common seal. A company being an artificial person, how does it function? Functions through its directors, board of directors. So there is common seal, and the common seal is the, I would say, official signature of the company, which is affixed by the officers and the employees of the company on its every document. Another feature of the company is your transferability of share. Section 44, the Companies Act 2013, provides that the shares held by the members, they are all movable property, and as they are all movable property, they can be transferred from one person to another person. And when the transfer will take place, that should take place in the manner provided by the Articles of Association. Now, going for the different types of companies, I would say as per the Companies Act 2013, companies has broadly been classified into various classes. So if I go for classification on the basis of liability, so we have company limited by shares. That is one where the liability of the members is very much limited by its memorandum of association to the amount, if any, that is unpaid on the shares held by them. Another, you have company limited by guarantee. As I told you a little while ago, this company is one where the liability of the members is very much limited by the memorandum to such amount as the member may respectively undertake by the memorandum to contribute to the assets of the company in the event of its being wound up. So these types of company may not have a share capital, may have a share capital, may not have also have a share capital. Such a company may be useful only when you don't have any working funds which are very much needed for the purpose, where the funds can be held from other sources like endowment, like fees, being charged, charges, donations, everything. And another types of company if we look for in this category, that is your unlimited company. So this company where if you look at the liability of the members, obviously this is unlimited. So the liability of the members ceases when he ceases to be a member. So the liability of each member extends to the whole amount of the company's debts, to the whole amount of the company's liabilities. But he will be entitled only to claim the contributions from other members. So till the time a company is going concern, company, obviously the liability will be limited to the extent of shares. But the creditors can institute proceedings for winding up of the company from their claims. So official liquidator may call the members for their contribution towards the liabilities or their contribution towards the debts of the company, which can be unlimited. But if I go for the classification on the basis of members, obviously you can have one person company. Company Act 2013 introduced a new class of companies where company can be incorporated by a single person. So the concept of one person company in fact was recommended way back in 2005 by the committee headed by Dr. J.J. Irani. And Section 2, subsection 62 of the Companies Act 2013 defines one person company as a company which has only one person as a member, unlike your sole proprietorship as a form of business organization. And this is also one person company is a separate legal entity with the limited liability of the member. On the basis of the members Apart from one person company, you can have private company, you can have small company, you can have public company. So in case of private company, it means a company having minimum of share capital, and it restricts the rights to transfer the shares, except in case of one person company limits the share of its members to 200. And in case of private company, it prohibits any kind of invitation to the public, to the subscriber, or any kind of securities of the company. But in case of small company, which is given under section 2, subsection 85 of the Companies Act 2013, which means that other than public company, because if we are talking of other than public company, the paid-up share capital of which doesn't exceed 50 lakhs rupees or such type of higher amount as may be prescribed, and which shall not be more than 10 crores. And if you look at the turnover, from the turnover point of view, the turnover of which as per the profit and loss account, for the immediately proceeding financial year doesn't exceed 2 crores or such higher amount as may be prescribed from time to time, which shall not be more than 100 crore rupees. So in case of private company, private small company, it is no doubt private, but the paid-up capital not more than 50 lakhs and the turnover not more than 2 crores. But if you look at the public company, that is the gigantic form of the company, it is not a private company. And since it is not a private company, it has minimum paid-up share capital as may be prescribed. So the status of the private company, which is subsidiary to public company. So obviously private company which is subsidiary of a public company shall be deemed to be a public company, maybe for the purpose of this act. Even where such subsidiary company continues to be private company in its articles. But if I consider the control, on the basis of the control, you can have holding companies, subsidiaries companies, and associate companies. What is holding and subsidiary companies? Holding and subsidiary companies are relevant terms. A company is a holding company of another. If the other is a subsidiary, so company shall be deemed to be a subsidiary of another if other company controls the composition of the board of directors, that is more than 2/3, and you exercise control more than 1/2 of the total share capital, either at its own or together with one or more of its subsidiary companies. But in case of associate company, it means a company in which other company has a significant influence. When I say significant influence, either it is control of the least 20% of the total voting power, or it is the control of participation in the business, or the control of decision under an agreement. But if I consider the basis as the access to capital, you have listed company, you have unlisted companies. Listed companies, company which has any of its securities listed on any recognized stock exchange. Similarly, unlisted, it means company other than listed companies. And we have got other companies like government company. And if you are talking of government company, where you find that not less than 51% of the paid-up share capital is held by the central government or in the state government, or partly central government, partly state government, or more. So in this case also you have foreign companies, And when we are talking of foreign companies, that is any company or anybody, corporate body, which is incorporated outside India. But when I say it is incorporated outside India, but it has a place of business in India. And in that case, whether business by itself or through agent, or it is physically through electronic board, that is your foreign company. But in case of section and company, which is formed to promote the charitable objects of the commerce, science, arts, sports, education, social science, religion, charity, your protection of environment, etc. And such company intends to apply its profits, promoting the objects, prohibiting the payments part and the dividend to its shareholders. You have also another type of companies, dormant companies, where the company is formed and registered under this act, but these are all for a future project or to hold an asset or to hold intellectual property rights and has no significant accounting transactions. Company is an inactive company, may make an application to the register of companies in such a manner that may be prescribed for the purpose of obtaining the status of a you can say dormant company. Similarly, you can have active company, you can have nifty companies. You can have inactive companies also. When I say dormant, where company is formed registered under this act, and that too for a future period, future project, or to hold an asset or intellectual property which has no significance accounting transactions. Such a company or an inactive company may make an application to the register in such a case, in such a manner as may be prescribed. That is for the purpose of obtaining the status of a dormant company. So in that case, you have got inactive company, you have got nifty companies. Inactive companies which has not been carrying on any business or operations, but it has not made any significant accounting transactions during the last 2 financial years. It has even not filed financial statement, another annual returns during the last 2 financial years. Similarly, you have got nifty companies, also called as mutual benefit. It means you are setting up a company and which means you are setting up a company and which has not been the purpose that in case of, as I told you, in case of inactive company, not been carrying out any business or operations, but in case of nifty company, it is mutual benefit society. It means the company which the central government may by notification in the official gazette declare that the nifty or the mutual benefit company or the mutual benefit society, as the case may be, because the objective is to lend money and to borrow money. Who are the beneficiaries? To the members. What is the purpose? Purpose is mutual benefit. So you try to see that there should be financial inclusion for all the purposes. Similarly, you have got public financial institutions by virtue of Section 2, subsection 72, the Company Act 2013. If you look at the LIC, Life Insurance Corporations, established under Life Insurance Corporation Act 1956, if you look at the IDFCL, Infrastructure Development Finance Company Limited, If you look at the other things, that is your specified company refer to your Unit Trust of India Act 2002. Now, question arises that how company is formed, how the company is formed. That means we are looking for the formation of companies, we are looking for the incorporation of companies. If we look at the section 3, clause 1, it states very clearly that when you are talking of a company, company may be formed for any lawful purpose. Obviously, 7 or more persons when the company is to be formed to be a public company. Minimum is 7, maximum is unlimited. Similarly, if we look at the manpower strength, that is your 2 or more persons, where the company is to be formed, that is to be private company. And 1 person where the company is formed in the 1 person complex. And in this case, we have to be very, very sure that 7 persons or more are available when the company is to be formed to be a public company. But the same thing will not happen in case of private company. In case of private company, you have got 2 or more persons where the company is to be formed. And in many cases, 1 person where the company is to be formed by 1 person company. So in the formation and the incorporation, you go through certain stages. The formation of a company is a lengthy process in the Indian context, involving the completion of the legal formalities and the procedures. It involves the very purpose, the promotion, it involves the registration or incorporation or commencement of the business. Who is important over here in the formation? The promoter. So the first stage of a company is promotion. Also, although this is a stage and idea, everybody requiring for their own purpose and to carry out the day-to-day business, which is conducted by an individual or a group. And the company, the floors of the company enters into preliminary contracts, agreement, purchases made, purchases of property in yours, you can say own name. So the promoter, who is a promoter? Obviously, the floors of the company, or you enter into the preliminary contracts or the agreement which you are more concerned about, the purchases of property, is in his own name and hands it over to the company or its incorporation called as promoter. So it is a body of corporate and having a person acting merely in a professional capacity. And that is how the Companies Act 2013 defines the term promoter, who has been named as such in a prospectus or identified by a company in the annual return. So when you are talking of a promoter, obviously promoter is, which means a person who has control over the affairs of the company, and directly, or you can say indirectly, whether the shareholder, directors, and otherwise, who is going to see or exercise control. And what is more important over here, that is your registration or incorporation. When you are talking of registration, so Section 7, Subclause 1 of the Companies Act 1913 provides for the detailed procedure for the incorporation of company. filing of the documents, information providing through the document to register companies. So you need to submit memorandum of association, articles of association, and a declaration to be given by the persons who is engaged in the purpose of the company. He may be a lawyer, he may be a chartered accountant, he may be a cost accountant, everything. And there is a declaration from each of the subscriber that the memorandum and the articles of association, they, in fact, from person's name as the first director, if any articles stating that. So everything address, correspondence, register office, address for communication. The particulars, name, buildings, the surname, family name, directors, everything have to be mentioned over there. The register shall register all the documents and the information in the register and issue a certificate of incorporation. Now you can start your business operations. Another feature could be your election of, I would say, the of all kinds of necessity from the legal point of view. So here, the register shall not, why shall allot, I would say, I wanted to make you all confused to the company. You can say corporate identity number on and from the date mentioned in certificate of incorporation, it will be included in the certificate. And finally, there will be commencement of business. According to the section 10, subclause A company incorporated, a company commenced of the Companies Act. Rather, it would be appropriate to mention companies within bracket amendment ordinance 2019, which is the latest, having a share capital and shall not commencely that shall not commence any kind of business, rather I would say, or exercising any kind of borrowing provisions. So after talking about this, we must look at what are the principle or what are the principles that you must follow. What are the principal, I would say, guidelines which is there. So if you look at the principal documents which are needed for the purpose of the company, in fact, there are three important documents of a company. One is your memorandum of association, another is your articles of association, and the third document is your prospectus. When we talk about memorandum of association, that is the charter of a company which lays down the objects of the company, the purpose for which company has been set up, and all the specific functions, all the specific operations and limitations. And when we look for the articles of association, this is also another document that constitutes that all the rules, all the regulations for the conduct of the internal management of the company. Because without that, you cannot have uniformity, because without that, you cannot have consistency. So in the memorandum of association, you have, if you look at the contents, you have a name clause, consists of the name of the company with the last word limited in case of public limited company, and private limited company in case of a private limited company. And if the company changes its activities which are not reflected in its name, so it shall change its name, and that should go in line with its activities, and it must be completed within 6 months. from the change of activities after complying with all kinds of provisions mentioned in the Act as applicable to change of name. Similarly, domicile clause, that means registered office, the administrative office, name of the state in which registered office of the company is to be situated, and the companies are on the from the 15th day of the incorporation and all at all times thereafter. So they have a registered office capable of receiving and acknowledging all kinds of correspondence, communications, and notices as may be addressed from time to time. Similarly, in case of memorandum association, you have got some object clause. Object clause will speak for the main object, what is the incidental objects. So if we look at any company, the main object which the company wishes to pursue at the time of incorporation, and objects incidental to the main, that is to the attainment of the main object, and you need to have other objects. Similarly, you have liability clause, you have capital clause, you have got association clause, everything. Now coming to the articles of association, obviously, articles means the articles of association of a company, and as originally framed or as originally altered from time to time, or you have applied in pursuance to any previous company's law or company's act. So these articles are nothing but the rules, and the rules are commonly known as the laws of the company. So these experts, these expresses a contract between the company and its members, and hence we have to see that what are the contents of the company, the regulation of management, it is there, and such matters as are prescribed under the rules. However, the company may also include additional matters as may be considered necessary from the management perspectives. And there is also provision for retrenchment. Usually the articles of association, they don't do it. That may be altered by passing special resolution. And you have got other legal documents like your prospectus, because prospectus to be dated, where you are inviting public to raise funds, and the prospectus is signed, and you have a total state-wise information, and you set out such reports or the financial information as may be prescribed from time to time by the Security Exchange Board of India in consultation with the central government. So when you are talking of the prospectus can be issued only after delivery to register for filing. And as a matter of fact, prospectus shall not be valid if it is issued after days from the date on which the copy thereof is delivered to the register of companies from that day. So you have got different types of prospectus like red herring prospectus or self prospectus, information memorandum, because in case of red herring prospectus, it means a prospectus which does not include your complete particulars of the quantum price of the securities and information pertaining to the company's operations, company's prospectus, but doesn't include any type of key details of the issues, such as there will be no price, there will be no price, again the disturbances, those which are there. So another is your, apart from your self-hearing prospectus, you have got also another self-prospectus and information memorandum. When we are talking of self-prospectus, obviously we look at it is a prospectus in respect of which the securities or the class of securities included therein and they are all issued for the purpose of subscription in one or more issues over a period of time without any issue of a further prospectus which is to be made. So issuer is always permitted to offer or to sell to the public without any separate prospectus, because when we look at the legality of the object, obviously the question now is answered. So in case of information memorandum, this is required to be filed by the company filing a self prospectus, which must contain all material facts relating to new charges being created, all being material facts relating to changes in the financial position of the company, or it could be between your selling and when we are talking of the change, obviously the change in the financial position of the company as have occurred between the first offer of the securities or the previous offer of the securities and the succeeding start of the securities must be made available. Other charges which may be prescribed from time to time, register within the prescribed time, the period of the issue, and you have got second or subsequent securities under the self prospectus. Similarly, you have got abridged prospectus. A prospectus, as I told you, is a very voluminous document and one cannot be expected to read it completely. So an abridged prospectus is a summary of the main prospectus containing such details as prescribed by Security Exchange Board of India (SEBI). You have got a deemed prospectus, that is your offer for sale. The document offer for sale is an invitation which is being made to the general public to purchase the shares, or to purchase the shares of a company through an intermediary body such as issuing house, such as your merchant bank. So a company may allot or a company may agree to allot any shares or any debentures to an issue house, and there or the debentures directly or to the public through issue of prospectus. Securities will be considered to be offered for the sale to the public if it is shown. And there are several matters to be stated in the prospectus, like the name, address, register office of the company, the date of opening of the issue, closing of the issue, the statement made by the board of directors about their separate bank account where all money is received out of the issue and to be transferred, and disclosure, that means disclosure of details of all monies, including utilized, unutilized monies out of previous issue in the prescribed. So the prospectus must contain the details about the underwriting of the issue, consent of the directors, auditors, bankers, expert opinion, the authority for the issue, and the details of the resolution passed before, the procedure, the time schedule, everything has to be taken into consideration. And now coming to the share and the loan capital, obviously the public company, what it does, it raises the necessary funds. How does it fund? By issuing shares. How does it? By issuing debentures or by accepting public deposits. Now, in the document, you have to mention the share capital, and the share capital is the capital which is raised by the company by issue of shares. In fact, it is the corpus or fund to be used for the joint of the company, and the memorandum of company, if we look at it, provides for share capital clause, and that is why company is limited by guarantee, or it is limited by, you can say, on just like your unlimited companies, need not have the share capital at all. And here you should have nominal or authorized or registered capital, issued capital, subscribed capital, called off capital, paid off capital, uncalled capital, reserve share capital. And with regard to shares, you have got different types of shares. According to the provision under section 43, the share capital of a company which is limited by shares shall be of two kinds. Either it is equity share capital or it is preference share capital. So in the case of preference share capital, this is the one part of your issued capital, share capital of the company, limited by shares which carries or would carry a preferential rights with respect to the payment of the dividends to be made or the repayment of capital in case of winding off of companies. And in all these cases, what is more important that we have to see whether the company is in a position to take care of the entire operation. So that is why what is the need of the hour? Company management is the need of the hour. Since company, as I told you a little while ago, is an artificial person, and its affairs are to be managed by the natural persons. So there it is the problem. The management of incorporation is a collective representing of the different issues, collective responsibilities, and those who manage the corporation are known by various names, like names like directors, names like managing directors, like company shareholders, because all these things are needed to represent their interest. So in the company management, we look at the board constitution and power. And when I say board, by default it is the board of directors. They are all selected according to the procedure prescribed in the that means Company Act 2013. And here it defines board as a collective body of the directors of the company. And that is how the team, all public companies are required to have a board of directors, or you can say include the number yours from inside and outside the organizations. So company board, that means the composition of the board shall consist of individuals like you and me, thus no body corporate, no association, no firm shall be appointed as director of a company. So every company to have at least one resident director who must have stayed in India at least for a particular period of time, but it should not be less than 182 during the last financial year. And the constitution, one women director has to be there. And at least you can say 1/3 of the total number of directors as independent directors, and fraction is to be rounded off to 1. And the regulation 17 of the Security Exchange Board of India, regulation 2018, they further elaborate the composition of board of directors of the listed companies, because the board has got certain powers, powers like to make calls on shares for unpaid money, to borrow money, to invest the funds of the company, to grant loans or to give guarantee or provide security for the purpose, to diversify the business of the company, or to approve the amalgamation or to go for merger or acquisitions, and to appoint or to remove any managerial personnel, and the appointment of the internal auditors and the secretarial auditors. And in this case, what you do, you invite or accept or renew the public deposits and related matters. Here you have also restriction on power, even though they are the highest. So that in both the cases, what we look for, we either invite or we accept or we renew public deposits and related matters. So there are also restrictions on power of the board. On the certain power can be exercised board only with the consent of the companies by passing special resolutions, namely to sell or to lease or to dispose of the whole or substantially the whole of the undertaking of the company, or to invest the amount of compensation so received as a result of any kind of merger, as a result of any kind of amalgamation, otherwise than in rural securities, or you always otherwise than in trust securities, to borrow money that exceed aggregate of its paid up share capital or the fee reserves or the securities premiums to remit, or to give time for the repayment of any kind of debt from the directors, because there will be persons working as directors in the board. So there is no exhaustive definition who will be the directors in terms of director, that is in the Act section 2 subsection 34 of the Act prescribed for that your director means directors so appointed by the board of the company. So only natural person can be the directors. And apart from that, when we look at the company and we find that the company is not heading in the right perspective, so we'll have certain meetings, number of time meetings. Company meeting can be classified as shareholders meeting through annual general body meeting or extraordinary general meetings, or there could be class meetings, board meetings, and finally you come out with the creditors and the debentures holding meeting. So the shareholders meeting, suppose you are talking of, you have got annual general meeting, you have got external general body meeting, you have got class meeting, everything. So in case the organization doesn't do well, obviously there should be winding off of companies. So your winding off of a company is a process by which the life of a company is brought to an end. So obviously it's a property administered for the benefit of the members, obviously, or the sometimes is the creditors. So as per the section 2, subsection 94A of the Companies Act 2013, the term winding off means winding off under this act, or you may say liquidation under this act. So in both the cases, there are different modes of winding up. Either you go for winding up by the tribunal, or you go for winding up by the voluntary. So if you go for winding up by the tribunal, so obviously a company has to, on a petition, has to give a petition under section 272 be wound up by the tribunal. And if the company has gone for any special resolution, resolve that the company be wound up by the tribunal, or if the company has acted against the interest of the sovereignty and integrity of India, so security of the state is likely to be affected, or the friendly relation with the foreign states, public order, decency, everything has to be taken into account for the purpose of that. And if we look for the company, petition for winding up company can be made by the company or by any contributory or contributories. So all any one of the person specified above, as I told you little while ago, the register, the person authorized by the central government in that behalf. Similarly, the tribunal, on receipt of the petition for winding up within 90 days, the days pass to any of the following orders, like dismissing it without any cost, or making some kind of interim orders, provided the judge would like to think fit, or he may go for interim order as it thinks fit. Similarly, another kind is also there, that is very much voluntary, so voluntary winding up. So we have got chapter 5. In the chapter 5, we have got voluntary winding up, and that is chapter 5 of the insolvency of the bankruptcy code of India 2016. It deals with the voluntary liquidation of the corporate persons. So voluntary liquidation proceedings can be initiated by the corporate persons, and in the corporate persons, one thing we have to be very clear, that it has not committed any default. So whenever you go for declaration, obviously we look for the declaration from the majority of the directors, those on the board of the company, and it is all verified by an, and the verification can be done through an affidavit, which is requiring that the affidavit must state one thing, that the all the information made, and we have made full inquiry to the affairs of the company, and they have formed an opinion that either the company has no debt, or it will be able to pay whatever dues, whatever debts over a period of time it has created in full, and that should be from the proceeds of the assets which are to be sold in the voluntary liquidations. So with this, we come to an end of today's session. Thank you very much. Have a nice time. Good day.